I really appreciate the opportunity to present this training on the Brown Act. I wanted to note before I begin that this training is based largely on the training that the prior town attorney and prior town clerk did about 2 or 3 years ago. And it's been updated, refreshed, given that there's been some new state laws, as well as some new local policies around the Brown Act. And as the mayor mentioned, I'll go through my slides. I do have about 30 of them, but some of them are pretty quick. And then there'll be the opportunity for public comment. And I do intend to, if you have questions in your public comment, I will endeavor to answer any questions that come up in real time. So let's go ahead with the next slide. All right, so we're going to go through the basics of the Brown Act, what it is, who is covered, what are the requirements, and what are the consequences of violating the Brown Act. All right, next slide. In terms of what it is and what the legislative policy is behind it, the intention is that all meetings of the legislative body of a local agency shall be open and public, and all persons shall be permitted to attend any meeting of the legislative body of a local agency, except as otherwise provided in this chapter. So there are exceptions. Next slide. As far as who is subject to the Brown Act, elected bodies, so the town council, of course, is subject to the Brown Act. In addition, all commissions and committees that are appointed by the town council are also subject to the Brown Act. So for example, here, the Planning Commission, ASCC, Conservation Committee, and EPC, who just was here earlier, are all Brown Act committees. In contrast, there are some committees here in the town that report to the town manager. I refer to them in this slide as town manager committees. And because they do not report directly to the council and are not appointed by the council, are therefore not subject to the Brown Act. And I've listed them in this slide. I'm not sure if I got all of them, but I think that should encompass most of the town manager committees. Finally, I just wanted to mention that there's also a distinction in terms of subcommittees of legislative bodies are either subject to the Brown Act or not. And there's a distinction between standing subcommittees and ad hoc subcommittees. I'm actually not sure that we have any standing subcommittees on this particular council. A lot of other councils do. For standing items like Finance Committee is oftentimes a standing council subcommittee. And they have continuing jurisdiction over finance. And those meetings are on a particular time schedule and are subject to the Brown Act and are open and public. Ad hoc subcommittees, on the other hand, deal with items that are by nature temporary in nature. So for example, this evening, the council created an ad hoc subcommittee for the town manager recruitment. That of course is a temporary venture, given that their work will be complete once the town manager is hired. All right, next slide. All right, basic requirements. I know the council is and probably most folks watching the meeting tonight are generally familiar with them. The idea is that the meetings must be open and public. The agenda must be posted at least 72 hours in advance for regular meetings and 24 hours in advance for special meetings. As a reminder, the regular meetings of the council are the second and fourth Wednesday of the month. Those are set in our Muni Code. Those are the regular meetings. But then if the council has special meetings, for example, there may be a need for a special closed session on a particular item. And those can be set with just 24 hours advance notice. Of course, the public must be given an opportunity to comment on each agenda item before any action is taken. And all votes do need to be in public. In other words, this last bullet is basically just saying no secret voting. All right, next slide. Okay, so what constitutes a meeting? this is where things can get a little bit dicey. Of course, the intention here is that meetings are held when a quorum of the legislative body meets, and that meeting has been publicly noticed. What we need to be careful for, of course, are generally unintentional meetings, which can occur with a serial communication of a majority of the legislative body that takes place outside of a noticed meeting. And I'm going to have a few examples of how that can take place with the next slide here. All right, so this with a great image here of a daisy chain. So this is oftentimes referred to as a daisy chain meeting or serial meeting. And what to look out for here is a daisy chain process when member A of a legislative body contacts member B and says, hey, I really like this project. I really think I might vote yes for it. Member B contacts member C. I'm not suggesting any of you ever do this, but this is just for example purposes. And member C contacts member D, and so on. And essentially, once you've hit a quorum of the legislative body, that can be a serial meeting outside of the scope of the Brown Act, and that's what you need to watch out for. And the next example is kind of a similar concept, but a spoken hub. And this is where one individual, in my hypothetical here, it's a staff member, communicates with various different members of the legislative body. And instead of just having a one-on-one conversation, shares the thoughts of another member of the legislative body, so that staff person, the hypothetical staff person, acts as sort of the hub and shares that information in a way that can reveal the views of legislative body, of members of the legislative body to one another. So that's something to look out for. I do want to contrast it with a practice that's very common and allowed under the Brown Act, which is individual briefings. So, for example, when the town manager meets with individual council members or just two of them to review the agenda, for example, for an upcoming meeting, that is permissible. And just so long as that city manager is not acting like the hub in this hypothetical. Right, next slide. So this is the practice tip, and this, I can't take credit for this cute little image here, but that was in the prior slide deck. Have a Brown Act buddy. This is permissible since two council members or two commissioners may talk to one another about a particular topic without violating the Brown Act. And I guess the only word of caution here is it can get tricky if you have a Brown Act buddy for, say, housing topics and another Brown Act buddy for budget topics. Just to keep those straight can be challenging. So that's just something to look out for if you do have a Brown Act buddy on the council or the commission. For those of you watching from commissions and committees. All right, so in terms of the public's right to comment, so of course the public has a right to comment on each agenda item before any action's taken. At regular meetings, there is always an opportunity for public comment. Here it's called oral communications. This is for items not on the agenda. And the Brown Act actually requires us to have that oral communications item on regular meeting agendas. Special meeting agendas do not need to have that that oral communications item for items not on the agenda. I will say, I've noticed that here we often do anyway, nothing wrong with it, but that is an optional item for special meetings. This was in the last set of slides, but I think it's bears repeating that the public speaker is not required to identify themselves or where they live. I think people like to do that anyway, and that's completely fine. It's up to them, but it's not required for them to do so if they do not wish to identify those personal information. And then finally, I wanted to, for in terms of the public right to comment, I wanted to note that, of course, the chair or the mayor has discretion to set time limits, but may not limit it sort of negative comments or criticisms. So those, we do need to hear those negative comments and criticism. But if things get sort of inappropriate, such that decorum is interrupted, then that it can be a situation where the public's right to comment may be infringed upon. I will say I have not noticed that in this community. All right, in terms of responding to comments, so the public can of course comment on any topic, but the legislative body may only discuss topics that are on the agenda. Now, when things come up in oral communications, there are a few things that the council can do in terms of non-agendized items. For example, something might come up in oral communications that's not agendized. Sometimes the mayor refers that person to the manager or other staff members for further, information. Or they can, or you can, ask staff to report back, or the council could actually ask for that item to be agendized following the process that it has for placing items on future agendas. So those are all options for responding to comments for items not on the agenda. All right, so we're gonna switch gears here a little bit and talk about social media. I also borrowed this slide, and I just realized today as I was going through it that it is already dated because it shows a little app for Twitter. So, but you get the idea. So this is a slide about AB 992, which was a state law from 2020, where the legislature, sought to clarify the Brown Act rules regarding use of social media. So the main takeaways here are that members of the legislative body may use social media to provide information to the public and answer questions, solicit information. And they can also read another member's posts. But they cannot use social media to communicate with each other. So that says to communication with each other, that should be communicate with each other, even if it's less than a quorum. So that means if you see your colleague post something on X, not Twitter, and or PV Forum or Facebook, what have you, you can read their post, but you may not comment on it, nor can you like or heart it. And that is something that's true for all forms of social media. That was the AB 992. But there's more. So this is where some new information, new slide, that I added for this presentation. So after AB 992, this town council just last year actually adopted an e-communications policy, which goes above and beyond AB 992, I would say, in terms of restrictions on electronic communications during public meetings. So first, I just wanted to mention that this policy is in a resolution, and it's posted on the town council webpage to make it easy to find. I was personally having trouble finding it, and I will say our interim clerk got it posted up there. So like I mentioned, it does track AB 992, but it goes above and beyond. Primarily in that it requires that council members and actually all of our Brown Act bodies, all of our committees and commissions that are subject to the Brown Act may not use e-communications during public meetings, with the exception of urgent personal matters. And there was, this council held a few meetings about this policy, and my takeaway in terms of the interest here was that during meetings, we want to make sure council members and committee members are of course paying attention to the discussion, and not distracted with e-communications. I think that was one of the key reasons for that policy. I wanted to also just mention that this policy also includes policy around email practices to ensure compliance with the PRA stands for the Public Records Act, as well as record retention rules. I'm not going to get into the public records because that would probably add another 30 minutes to my presentation. But that e-communications policy is mindful of our duties under the PRA and our record retention rules. And then the policy also includes a requirement to ourselves that we include something on our website, just warning the public that the communications that they send into the town are public documents. And that is up on our website. All right. So I also wanted to mention that we also have a policy that was adopted in 2022 regarding texting during public meetings. This policy is largely supplanted, I would say, by the 2024 policy, because the 2024 policy goes above and beyond this 2022 policy. So as you may all recall, this 2022 policy provides that there's no texting or emailing fellow committee members or consultants during public meetings regarding committee business. And then there are various exceptions. Well, it's okay to text staff or text the chair to report an internet problem or text the chair to request a break. There are various exceptions there. But as a reminder, the 2024 policy has says that there shall be no e-communications, i.e. also no texting, period, during public meetings. So these exceptions are, I'd say, largely moot given the 2024 policy. Okay, next slide. All right, so I'm gonna switch gears and talk a little bit about the exceptions to what a meeting is under the Brown Act. And this is probably where I get the most questions, I would say. And I have a really great cheat sheet book that I have a slide about at the end. So don't feel like you have to commit these all to memory. But in terms of the key exceptions to the Brown Act, one, actually, I already mentioned this one, but individual contacts, either individual contacts between committee members or between a committee member and another person, does not constitute a meeting. So that's where the concept of the Brown Act buddy comes in. And of course, a committee member, council member talking to a staff member also does not constitute a meeting. Now, there are a number of exceptions where a majority of you all, and this is committee members, but this is also applied to council members, can attend certain events without it being a Brown Act meeting. So for example, conferences that are open to the public, a majority of the council or committee may attend those without it being a Brown Act meeting. A local public meeting, such as a community outreach meeting, you could have a quorum of a legislative body attend. An open meeting of another public body, for example, Board of Supervisors meeting. A social or ceremonial event. There's the example of PV Palooza in here. You could have a majority of the council. Now, one major asterisk to all of this and note and thing to be mindful of that is that the members present cannot discuss town or commission matters amongst themselves. So it's fine, you get together and you can talk about how great the food is at PV Palooza, but you cannot have the majority of you talking about next week's agenda, for example. Let's see. I wanted to say anything about that. I think it's ready for a quiz. Yes, it's ready for our pop quiz. So this will be actually a good way to kind of get into these exceptions. So the first, and don't worry, you don't have to answer these questions. I have a slide that actually answers the question, but this is just to get us all thinking. So the first one is you have members of the current town council are invited to a town employees retirement party. Should, and it says members, but let's just assume, so should the event be noticed as a special meeting if there is a potential that 3 or more council members will attend this party? And the answer is no. This falls under the category of a social gathering. And I apologize for the image here. I was going to change it because we would never serve wine at a retirement party or any party here. That would be unethical and contrary to other legal obligations. But you get the idea that it is permissible to have a quorum or more of you attend the social gathering for the retirement party. Okay, next question. Members of the ASCC are interested in learning what the town council plans to do regarding short-term rentals in Portola Valley. 3 commission members attend a town council public hearing on short-term rentals. Is this a violation of the Brown Act for a majority of that commission to attend? All right, and the answer is no. This falls under the category of a meeting of another body, so that those ASCC members may attend the meeting. Next one. So we have a follow-up question. Okay, what if a quorum of the town council wish to attend a meeting of the ASCC? Is this a violation of the Brown Act? I don't have a nice another picture for this one, but the answer is no. The same exception applies. It's a noticed public meeting. It's already a Brown Act meeting. That said, I do have a sort of word of caution here that the council members should be mindful of what I've referred to as getting ahead of the process. Particularly when the item has the potential to come before you as at the council level. And so, you're being there potentially could have a perception of putting a thumb on the scale in terms of how they should vote. So that's one thing to just be mindful of. And that's what I refer to as you want to be mindful not to get ahead of the process. And then also the council does have liaison assignments for all of the committees and the Brown Act committees and commissions. And so it can create confusion, if you have more than the liaison attending, that can be confusing in terms of liaison assignments. So I would just put those as sort of words of caution. And of course, all of our meetings are recorded, and you can always just watch the video after it's posted to avoid the appearance of a violation. Okay, next pop quiz. So next one here, we have members of the Parks and Rec Committee are all, and is this one still a Brown Act committee? No, I can't remember. Let's assume that it is a Brown Act committee, are all invited to attend a webinar on parks and open space grants. Is this a violation if a quorum are present? The answer is no. This falls under the category of a conference open to the public. So there they all are with their conference badges. All right, so that's, I think, the end of our pop quiz, and we'll just go into some other nuts and bolts. Sorry about all the text here. Required agenda elements. So key here is that, of course, we've got to include the date, time, and location of the meeting. The agenda needs to inform the public about the scope of the intended plan so that they can decide whether to attend or participate. Each item needs to have a brief description of the item of business to be discussed. And the Brown Act actually does give some guidance here on what it means by brief description. Generally speaking, 20 words or less are sufficient, unless it's a really complicated issue. And we do see that sometimes, particularly with the ASCC and Planning Commission agendas. They often do exceed 20 words when there's lots of different approvals and sub-approvals. But generally speaking, 20 words or less is sufficient. Of course, we have to provide for public comment. We talked about that. The agenda needs to include options for ADA accessibility. And the agenda must be posted at a location that is freely accessible to members of the public. And we talked about the time frame, 72 hours in advance for regular meetings, 24 hours in advance for special meetings. And then in addition, writing submitted to legislative body within 72 hours must be made available upon request. And we comply with that by posting public comment in advance of our meetings on the town website. Okay, so next item, we have some do's and don'ts for agenda titles. So I mentioned that, we need to give the public fair notice of what is going to be discussed. And so here are some examples of ones that are, kind of room for improvement. Agenda title that just says town events or housing element or greenhouse gas emission targets. It's much better to include a verb if you include a verb in your agenda title, chances are it's going to be a good agenda title. So for example, discuss the schedule for 2025 events. That would be a good agenda title. Discuss housing element and forward committee's recommendation to town council. Discuss the community-wide greenhouse gas emissions target funding and next steps and provide guidance to the climate action plan subcommittee. Those have additional information that are helpful for the public to know what to expect at the meeting. All right. So the Brown Act also has some really cumbersome rules about attending remotely. And this body is actually pretty well familiar with these rules because we've availed ourselves on them several times in the last several years. Now, this is referred to as the traditional rule. I probably didn't update the slides because during COVID, there were additional rules that allowed for remote attendance during public meetings. But all of those special rules have expired. So what options are available now are primarily fairly cumbersome, but essentially if a council member, commissioner knows in advance that they are going to be out of town during the meeting, there are options for attendance as long as you do all these things. So first, the location of the member has to be listed on the agenda. The agenda itself must be posted at the remote location in an area that is freely accessible to the public. So that means at the hotel business center or your hotel room, the agenda needs to be posted. In addition, the remote meeting location of the member must be accessible to the public. So make sure your location is not on the 5th floor of a walk-up hotel, because that would not be accessible. And then in addition, for any voting that happens during that meeting where there is at least one member attending remotely, those votes need to be roll call votes for all motions. And finally, it's required that majority of the body be physically present at the notice regular location. So that means that up to 2 of you could be remote during a meeting because we need to have at least 3 here at the schoolhouse. Oh, yes, we do have one more pop quiz. Okay, good. Oh, I like this one. So this one is a member of the Conservation Committee, which is a Brown Act committee, is on vacation and wishes to participate in a committee meeting and vote by cell phone from her car while driving from Washington, D.C. to New York. Is this allowed? No. Member may not participate or vote because she is not in a noticed and posted teleconference location that is accessible to the public. The same thing would apply if she were to go on a cruise, an ocean cruise, because the public would not be able to get on the boat. So that is, and that was something that was yours, and you had that, and your attorney told you you could not participate in that meeting when you were serving on a board that was subject to the Brown Act. All right, so meeting minutes, I'm going to take a little divergence because this is not actually a Brown Act requirement, but it was in the prior presentation, and I think it's worth mentioning. The the town committee and commission handbook does contain rules around meeting minutes. I have not committed them to memory, but consult those in terms of the parameters for your meeting minutes. And then I'll just mention that record retention rules require that minutes be retained permanently. So that's an important job for our clerk. All right, now we're getting to, that was a fun stuff. Well, not really. This is where we want to steer clear of. So these are the consequences. Essentially, for Brown Act violations, lawsuits can be brought by the district attorney or any interested person following a correct and cure letter or a cease and desist letter. And I'm just going to pause there because that's a really important point that anyone can sue for an alleged Brown Act violation, but they first need to submit a letter that gives the legislative body an opportunity to cure the alleged violation. And that can be if there was something that happened that allegedly was not noticed properly, for example, that they could submit a correct and cure letter and say, counsel, you got to have a redo is essentially what the correct and cure would be. Or if it's something they're alleging is like a continuing ongoing practice that is in violation of the Brown Act, it may be that a cease and desist letter is what is a better fit. But basically either one of these is a warning and is a necessary precursor to any litigation, which is really good because it gives the body an opportunity to avoid litigation and have a do-over or review the letter and determine that, I see your point, but actually we respectfully disagree and we are not going to do anything to cure the alleged violation. Let's see. So yes, so anyway, the next step would be a civil lawsuit. And then some actions, if not cured, may be declared void by the court. And the remedy would be you've got to have a do-over. Criminal sanctions for intentional violations, that would be extremely rare. But the last point is worth mentioning that a successful plaintiff can recover their attorney's fees in court if they're successful and they prove a Brown Act violation. So that's a pretty heavy hammer there. Okay, we're getting to the end of my slides here, which is great. So it's almost time for comment and questions. But this slide, I just wanted to say this is a link to a publication by the League of California Cities or Cal Cities called Open and Public. And it's they're currently on version 6 or volume. Sorry, the most updated version is 6, and I think it's from just last year. They update it every other year, and it's a really terrific guide. I will say I use it every week, at least once, and it's my first stop when I do get a question, and even when I think I know the answer, I will often consult it anyway, just to make double, triple sure. So that's a great resource. And at this point, I will stop there. That's the end of my presentation. And Mayor, you can go ahead and ask any questions or just go forward with comment.
Well, I'll see if there's any public comment first. I'm not seeing anyone in the schoolhouse right now. Okay, there's 2 online. Rita Gomez.
Hi, thank you for taking my question. I've got 2 quick ones. Number 1, closed chats or limited chats that not everyone can be part of. Is that considered social media similar to Facebook or some of these other social media parts? How is that defined? And then my other question is, since the meetings are mostly hybrid when the system is working, do the participants have to do roll call in a Brown Act meeting if the meeting is being hybrid? Thank you.
Great. So I'll go ahead and take a stab at both of those questions. If I understood the second one well enough to answer. In terms of closed chats, now I understand that there is a social media platform used frequently in Portola Valley called PV Forum, that is kind of like Nextdoor in that it's not open to everyone on the planet, but there is, I think, some sort of a gatekeeping function. The Brown Act applies to PV Forum as well. And so the same rule applies there as would on Facebook or X or, Instagram. If a council member posts something on PV Forum, another council member may not like it or respond to it in comments. So that is consistent with AB 992 and is consistent with the town's electronic communications policy. In terms of the hybrid question and roll call votes. So I think the question was alluding to the fact that, well, we have the teleconference rules require roll call votes when you have, one member attending, one or two members attending remotely, and then 3 of you here in person. Roll call votes are always required there. Otherwise, while a meeting is hybrid, the members of the public are generally the folks who are remote. And so roll call votes are not required simply because there are members of the public that are attending remotely. I will say that the practice here I've noticed is to err on the side of roll call votes. So I think for clarity, and probably that's just the practice, which is fine and it may be helpful to members of the public that are attending remotely to hear the roll call, just to make it really clear how everyone's voting. So I think that's one of the benefits of roll call votes. But again, it's not required unless you've got 1 or 2 council members who are attending remotely.
Okay, thank you. 7562, you have your hand up.
Thank you for the presentation, but once again, who does the oversight? So I do have, and I believe many residents have concerns about practicality of the Brown Act. We have noticed several violations. We have reported them and nothing was happening. We don't have contact to you. We can report it to you, but you don't give your email. Perhaps that would be a new addition that you can do. But there's many concerns about the secret voting, daisy chain serial meeting, spoken hub serial meetings. You have people who belong to Alpine Hills. They can do it. I'm really concerned about the communication at PV Forum. I actually stopped participating in that because I'm not mind-liked in that community, and it takes a lot of effort to read through all the comments, absorb, and then submit a valid comment. So I think you should look at that, and I hope you will oversee it. It's a nice presentation, but if you can look it up. There were several violations, and that's why I brought it to the attention of Town Council, January 2019. I believe besides the Brown Act, it's very insightful for the public, but also for the committee members, because you're not training the committee members. There is the Public Service Ethic Law. It's published by the Institute of Local Governments, and they should all be trained in that. It's easy to just say something, but if there's no oversight, what's the point in it? So thank you.
I'm happy to respond to that one. So in terms of oversight, I will just, and I probably should mention this at the beginning, Portola Valley is a special place in that there are so many volunteers that serve on committees and commissions. And most of them are Brown Act bodies. And so it just is, it's going to naturally be, you know, a maybe more challenging place to make sure that, you know, everyone is complying with the Brown Act. That said, I would say this training tonight is really the first step in terms of the oversight. Really, I think a lot of it is education, because our residents don't want to violate the Brown Act. But it's really the training piece that I think is the most helpful. And, you know, and hopefully this is one, you know, the first step to, you know, to preventing violations. In terms of other resources, I wanted to, of course, mention that I don't think that the council wants me to be the overseer of all things Brown Act just because of the cost. But there are, you know, other resources for those committees that have a staff liaison. That's a very, you know, good start. And then also the council liaison can bring things to my attention or the manager's attention if there are concerns. The Brown Act is also, you know, the enforcement mechanism, and of course we don't want to go there, but it is the correct and cure or the cease and desist letter are also available where there are concerns. But that is, you know, I'm not recommending that because, of course, we want to prevent and educate and avoid a situation where we are receiving one of those letters.
Great, thank you. Betsy M.
Thank you. I have a question, as I've just gathered this evening, that these rules pertaining to remote access to your committee apply to Brown Act committees as well. My question is, we've not taken advantage of that. However, we have had on occasion a committee member that needed to call in from home, but we figured that they were not able to vote if it were a meeting at which a vote was going to be held. If it were important that committee member wanted to register a vote, do we need to post, because our committees need to get their agendas in on the Wednesday prior to the meeting, which in our case is 8 days before the meeting. Sometimes members don't have that much notice that they're going to be calling in from home rather than attending the meeting, or calling in from work for that matter. If it were posted as a late entry, as a red highlight 3 days before, is that satisfactory, or must it be noticed 8 days before? That's question one. And question two, public access. Would it include the member's home address or work address and necessitate a posting on the front door? Thank you for taking the question, and I appreciate the quick run through the Brown Act laws.
Great, thank you. Great questions. So in terms of the committees, if I was not aware of the earlier deadline, but essentially if an agenda is posted 72 hours in advance, it would comply with the Brown Act to include that information for the remote participation. I do want to just note, though, that it does take staff resources to provide agendas with remote locations. And I can't speak to this as well as the clerk can, but you know, I just want to be mindful of the fact that we do have quite a few committees and commissions that are subject to the Brown Act, and to be, you know, confirming addresses and making sure people have these posted, because yes, you are correct that even if it is a home address, that agenda does still need to be posted outside your front door. And you would need to welcome a member of the public to your home if that's where you are having the meeting. And I think that's actually one of the reasons that people generally don't use that option for their homes. It's more typically used, in my experience, where someone is staying at a hotel. And I think it works pretty well when the council member or commissioner perhaps rents out the business center of the hotel and then can post it at the door of the business center, that you don't have to, you know, worry about someone coming into your hotel room, which obviously is very rare. But like I said, this is a pretty archaic rule and you would need to let someone come into your hotel room or your home if that is where you're having your, if that is your teleconference location. I hope that answers the question.
Thank you. I am not seeing anybody else online at this point, so we can bring it back for council questions. I'm gonna actually start with Mary.
When I want to go to a planning commission meeting, for example, or want to attend, and I don't know who else is going to be there, if I'm remote, I mean, why isn't that okay?
It is okay. To attend the planning commission from a Brown Act perspective, it is okay to attend remotely. I caution you not to get ahead of the process when it's planning commission because they're oftentimes working on things that are going to be going to council. And so, but being an observer is okay under the Brown Act.
Craig, do you have any?
And Mayor, I think the important thing there is just that you're not interacting with that meeting. Like if you're just listening to a planning commission meeting, that's totally okay. Any of the things. So, I have a couple of questions. One, I think you answered, we do roll call voting, but we don't have to when all 5 of us are here. So you said that you have to keep, in your notes that, you have to permanently keep the minutes, but do you have to permanently keep the video recordings or the sound recording?
Christine, do you happen to know this question? The answer to the question?
Yes, I can answer.
Great.
I can answer that question. The town has a records retention schedule. So in the schedule, every type of document at town hall is identified. Now we're just updating it to come up to 2025, but in there is a video recording and typically in the old days, I'm talking from the 80s when I started, it would say like 30 days. It would be a, reel to reel tape or a cassette tape. We've come a long way from that, but until no longer needed. So that's basically what it is for video or recordings when no longer needed. Now, I can never see destroying a video because we would go back, it's a great record and we would go back, decades to see what happened in 2004. So, but there is a retention for every item. Of course, minutes, resolutions, ordinances are permanent, so you never get rid of that stuff, but.
Right, but that's my concern is video recordings are 2 orders of magnitude larger than a piece of paper. And so at some point you're talking significant storage costs. So it seems to me that it's actually very unlikely that you're going to keep video recordings forever. And if you don't, and we've decided that, oh, we can have summary minutes because we have all these video recordings, then you kind of get in this weird bind of, well, it's great until you don't have the video recording. So I think we should work, I mean, that's obviously something we should work on, is what our video retention policy is. And then I guess the other question, just clarification. So access to the location is a little bit vague in the sense that I had always heard it had to be ADA compliant. If nobody shows up requiring ADA, I'm like, I can imagine a situation where, like I imagine my house, for instance, I wouldn't mind if, people want to come and sit in my living room, it's cool, except I got stairs to get in my living room. So the question is, if somebody showed up the wheelchair and I said, sorry, I can't accommodate you, I can imagine saying, okay, well, then I can't participate in the meeting. That would be sort of one way to deal with that. But that's my question is, if ahead of time they couldn't get there, even if they never showed up, does that mean I could never basically use that space because it's not ADA compliant?
So I will say the Brown Act does not say ADA, but it says accessible to the public. So there's a little bit of nuance there, but the idea is you don't know who's going to show up.
Right.
And so if your remote location is not accessible, you can't use it because you don't know if someone's going to want to show up.
Yeah, so even, I was trying to get to the subtlety of, you can't use, like if somebody with ADA requirement showed up, then you couldn't use it for sure, right? That's like they actually did show up and you'd say, okay, so I'm not going to participate. But nobody shows up, you're still saying you can't do it, because even though nobody shows up, they might have shown up. Is that the right? way to
Right.
think
Well, we've
about
got to put it on the location on the agenda. So when I talk to you about, okay, where are you going to be,
Yep.
on that, at that meeting, Craig, is it accessible to the public? And if the answer is no, then I'd say, Craig, can you find another place to have, to attend, that is accessible?
it? Right, but the subtlety I'm trying to tease out, and I won't spend too much more time on it, is I don't have ramps in my house, but I could carry somebody's wheelchair down.
I see.
You know what I mean? So,
Yeah.
I mean, and that's the thing that was interesting to me, is it actually says accessible. It doesn't say ADA.
Right.
So who interprets what accessible means?
Yeah. I mean, I think that's one of those edge cases that,
For sure.
yeah.
But I don't think it's so uncommon, because unless you're in a hotel, then it starts to hit pretty quickly.
right. Right.
Right,
And I
which-
think the reality is that I haven't had to grapple with it very much because most council members don't want to have their home be the location because they don't want to either give the address or they don't want someone to show up at their house.
Right, and I'm not thinking just houses. I'm thinking of any space that might not be a hotel or something that,
Right.
that is ADA compliant. So,
Yeah.
okay.
Ellen?
One question that I'm assuming it's just this legislative body for social media, for instance, if there are other electeds on social media that you can,
Correct. So you can talk to a member of the Board of Supervisors who posts something. It's about talking to other members of the council, of the legislative body that you are on that presents the Brown Act issue.
great, thank you. Rebecca?
Do we have plans to hold this sort of training for the Brown Act committees and commissions? Or to make any kind of requirement that members actually go through the training before they actually are able to show up for their meetings?
So my understanding is that this training is going to be isolated in the video and shared with all of the committee chairs with the request that they share it with their committees.
Councilmember Flynn, yes, we're going to clip this video training, send it to all the chairs along with some other procedures of how to open up the meetings, record the meetings and clean up the meetings. So we definitely would love to have all chairs trained on the Brown Act.
And is there going to be any kind of tracking are they going to have to sign something to say that, yes, I've gone through this training or, I've certified whatever?
No, we would like them to watch it and just let us know when they're finished watching it, because it was really not even an hour.
Can I clarify? You're not saying only the chairs would be trained, because the violation would occur by the group. So the chairs would decide how to make that available, or?
We're not talking about an in-person training. We were just going to
Right.
send the clip to them.
Right. My only point was everybody should get that clip
Yes,
on that's all.
absolutely.
And then in terms of consequences, you spoke a little bit about that, but does Portola, do we as a town have defined consequences for violations of the Brown Act?
The major consequences that I'm aware of are not necessarily specific to the Brown Act, but just in terms of consequences for committees and commissions where there's a concern about an issue. And I don't have it committed to memory, but there is a process laid out in the committee and commission handbook for, I believe, the liaison to, sort of have an intervention with a particular committee members if there's a concern and elevate it to the mayor as necessary. And of course, the committees and commissions are Brown Act bodies and they report to you. So there is always the oversight by council in terms of the composition of the committee or commission when there are concerns about any individual.
So someone could be removed from a commission or committee.
Correct.
If they're engaged in Brown Act violations. And then in terms of, you'd spoken that we could be sued in the event of a Brown Act violation. my question is, you said that that the consequence of that is that they could then claim for the attorney's fees. So in order to win that lawsuit, do they have to claim harm to themselves, or is it just that they have to prove the existence of a Brown Act violation?
So my recollection, I haven't looked at the standard, whether there'd have to be some sort of like harm or prejudice to them recently. So I'm not certain of that answer. They would need to show a violation occurred. Whether there would have to be some prejudice to them, I just don't remember off the top of my head.
Okay. And then I just wanted to clarify that you said that there's a new handbook, or is this the old handbook for the commissions and committees? I
Just
think
the
there was
old-
some sense about rewriting it, I think, or.
Yeah, I don't have the most up-to-date information about that. I know there has been a desire to update and refresh the committee and commission handbook. And I don't know if Christine, if you have any more
I
information
believe
about
that's
that.
correct.
There,
Corey is working on it, I believe. But
oh, okay, because I thought Patty Dews was working and then it got put on hold for other things, but Corey? feel
Sure,
free.
if I may,
Yeah.
the town is working with Patty Dews to work on the final edit of the committee commission handbook. So I think that was left with prior town manager Etman before he departed, and I've been working with Patty to hopefully get that moving forward with Mark's help.
What would the next step be? Does it get reviewed and approved by the council?
Yes, we still have to do the internal review. I believe that there was the subcommittee or the committee that met with Patty and then that was handed over to the town staff.
Anything else, Rebecca?
No, that's it. Thank you.
Could
Uh,
I be, I'm sorry, could I just get clarification? I am not familiar with who Patty is.
Patty Dews.
Patty Dews is the chair of the Parks and Rec Committee.
Great, thank you.
Right, and it's also being updated to differentiate between Brown Act committees and town manager committees. So it's been a little bit more of a project than initially envisioned. But I would like us to be able to comment on that and review it
Absolutely.
at the appropriate moment. All right, and then the only other thing I have to say, these were all good questions, is the Cal Cities link that you had shown, I have found really, really helpful. They also, the old fashioned printout of it is easy to page through. It's a really good resource. So for people who like myself need to hear things a few times, getting a copy, having that link is really, really helpful. All right, that's it.